Today we will go with the legal dictation. Ready? 3, 2, 1, start. The development of any society has its roots in its social fabric, its economic well being, and the law and order situation and law enforcement mechanism. Disputes are a natural trait or fall out of development of man and society. The effectiveness of the dispute resolution system plays a vital role in the development of any place, society, or country. Para. The justice delivery system in India is the adversarial system where there exists a hierarchy of courts of law and the disputing parties are pitched against each other as adversaries before the judge who shall decide their case in the light of the applicable substantive and procedural laws of the country and as per the rules, stages, and procedures formed in this regard. Para. Though the need of such a formal adversarial system cannot be disregarded, the functioning of such systems have proved in numerous cases to be cumbersome, time consuming, and in many cases ineffective. The biggest evil of this system is the delay caused, which has resulted in a huge backlog of cases at all tiers of courts. This greatly affects the disputing parties as they are left remedialess for a considerable period of time and also embitters their relationship. The adversarial system hence has its own set of limitations to overcome which a great revamping of laws is required and which prospect appears elusive for the time being. Para. In such a scenario, it becomes imperative to look for alternative options or systems for dispute resolution. Such alternative options are known as the alternative dispute resolution system, which provide for a system or mechanism for resolving dispute outside the court and court procedures. The alternative the alternate modes constitute the modes of arbitration, conciliation, lok adalas, judicial settlements and mediation. Where arbitration is an adjudicatory process, conciliation, lok adalats, judicial settlement and mediation are non adjudicatory. Para. Mediation is defined as a method of non binding dispute resolution mechanism involving a neutral third party who tries to help the disputing parties each a mutually agreeable solution. Para. Simply speaking, mediation is a process to resolve disputes where the disputing parties get together with the assistance of a mediator to isolate issues, develop options, consider alternatives, and reach an agreement everyone can live with rather than having a settlement imposed on them by a formal body such as a court. It is a process for resolving disputes which is voluntary, non binding, and private, in which a neutral person can help the parties try to reach a negotiated settlement. Para. Mediation is not an adjudicatory process like the court or the arbitration, but is a process of negotiation and settlement wherein the parties themselves participate in reaching a settlement and the mediator plays the role of a catalyst that assists the parties in arriving at an amicable solution. The settlement arrived at is a result of the mutual negotiation between the parties, and the same can be concluded only if the parties agree to it. It is not adjudication by the mediator. He, therefore, does not impose his views and decisions on the parties. The settlement is a result of a consent of the parties, and once the settlement is arrived at, the terms thereof are recorded by the court, which then makes a decree thereon. Para. To understand or assess mediation as a mode of dispute resolution, it is desirable and necessary to understand its legal effect and placement in the relevant jurisdiction. Thank you.